What do you think would be one of the most important things you'd bring from your experience as a state court judge to that you could be able to transfer to experience as a federal court judge?
When I became a state court judge, I was amazed at the awesome responsibility that I had undertaken. I really thought a lot about, am I the right person to do this? I was surprised at the magnitude of the decisions I was making, and I really committed myself to being the best judge I could be. I think the transition to federal court will carry with it that transition, and I will understand the awesome responsibility that I'm undertaking and the importance of careful attention to the litigants in front of me, careful preparation. And so I think I understand that this is a very important position. It's very powerful, and it's so important to take it seriously.
You also, in private practice, represented plaintiffs under our right to know law in Vermont to get the information from Governor Dean, former Governor Dean's daily schedule during the time he was running for president. You used the Vermont Access Public Records Act. The Vermont Supreme Court ruled in your favor. Now, as one who has written in significant parts of the Freedom of Information Act, and one who's a strong supporter of it, I ask this question. You're going to be called as a federal judge, possibly to rule in requests under the Freedom of Information Act. Will you be able to take each case on its own and do the balance between oftentimes the balancing factor between the public's right and interest to know with the competing interest, possibly withholding information to either protect one's privacy or national security? Do you feel you can do that?
I do. I understand that it is a balance. I think we start with the presumption that freedom to information is important in a democratic society, that we have open courtrooms and open records, and that we look carefully at the balancing test, narrowly apply it, and make sure that information that is kept from public scrutiny is information that should be kept from public scrutiny because of a compelling competing interest.
Trial judge, you've had occasion to issue rulings involving Miranda warnings. You have any problem in facing the fact you may still be issuing such rulings in the federal court?
I don't, and I would say that even in a state court, if you're in a district court rotation, Miranda issues come up all the time, that it is a significant area of litigation in criminal defense, and I anticipate that would continue in federal court.
And I know your answer to this question is, we've discussed it. Would it make any difference to you who comes into your courtroom, plaintiff or defendant, what their political background, economic background, or even the nature of their case might be?
No, it would not.
All right. I believe you.